Question number 1001. A magistrate cannot release an accused on bail if the offence alleged is punishable with life imprisonment only, option A. Option B, a sessions offence. Option B, punishable with death or imprisonment for life. And option D, none of the above. Here correct answer is option A, that is punishable with death or life imprisonment. Question number 1002. A metropolitan magistrate may release an accused on bail in non-bailable offence except in the following cases if: option A, there is reasonable ground for believing that he has been guilty of an offence punishable with death or imprisonment for life. Option B, there are reasonable grounds for believing that he has been guilty of a cognizable offence and he has been previously convicted of an offence punishable with imprisonment for 7 years. Option C, he had been previously convicted on 2 or more occasions of a cognizable offence punishable with imprisonment for 3 years. And option D, all of these. Here correct answer is option D, that is all of these. Question number 1003. Which one of the following sections of CrPC provides for anticipatory bail? Correct answer is section 438 CrPC. Question number 1004. The bail granted to a person who is apprehending arrest is called? Correct answer is option C, that is anticipatory bail. Question number 1005. When any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offence, he may apply for anticipatory bail under section 438 CrPC. Question number 1006. Anticipatory bail under section 438 CrPC can be granted by Metropolitan Magistrate, Court of Session, High Court. Correct answer is Court of Session and High Court. Therefore, option D will be the correct answer. Question number 1007. Which one of the following cases relating to anticipatory bail? Here correct answer is option A, that is 𝐷𝐿𝐴 versus P.T. Manokaram. Question number 1008. For which of the following offences under CrPC application for anticipatory bail under section 438 can be moved? Here options are bailable offence, option B non-bailable offence, option cognizable offence, option D non-cognizable offence. Correct answer is option D, that is non-bailable offence. Question number 1009. Where any person has reason to believe that he may be arrested on accusation of having committed a option A, that is non-bailable offence, he may apply for anticipatory bail. Here option A is the right answer. Question number 1010. Bail to a person apprehending arrest can be granted by the High Court or the Court of Session, can be granted by Metropolitan Magistrate, is a matter of right, cannot be considered by any court. Here correct answer is option A, that is can be granted by High Court or the Court of Session. 1011. Anticipatory bail can be granted by the Session Court where the offence committed is bailable, where the accused has committed non-bail offence and has been arrested. Option C, when it is alleged that the accused has committed a non-bailable offence and is yet to be arrested. Here option C is the correct answer. Question number 1012. In which of the following cases the Supreme Court laid down the principles of granting anticipatory bail? Here correct answer is option A, that is Gurbakhsh Singh versus State of Punjab. Option A here is the right answer. Question number 1013. Can anticipatory bail be granted in respect of bailable offences, and if so, in what circumstances? Option A. Anticipatory bail cannot be granted in bailable offences. Bail can be granted only in case the petitioner is a woman and a minor or a sick person. There is no distinction between bailable and non-bailable offence so far as anticipatory bail is concerned. And option D, none of the above. Here correct answer is option A, that is anticipatory bail cannot be granted in bailable offence. Question number 1014. On an application made by a person apprehending arrest on an accusation of having committed a non-bailable offence, the High Court or the Court of Session under section 438 CrPC give the direction that option C, that is in the event of such arrest he shall be released on bail, is the right answer. Question number 1015. Filing of FIR is a condition precedent to the exercise of power under section 438 of CrPC. The statement is false. Question number 1016. Special power regarding bail under section 439 of CrPC is conferred on both High Court and Court of Session. Option A is the correct answer. Question number 1017. Who may cancel the bail under section 436 of CrPC by the subordinate court? Option A, the court which has given bail, High Court, Court of Session, both B and C. Correct answer is option D, that is both B and C. Question number 1018. Whether any condition imposed by a magistrate when releasing any person on bail can be set aside or modified. If yes, by whom, under which provision? Correct answer is option B, that is by a High Court or Court of Session under section 439 of CrPC. Question number 1019. In case an application for a bail is filed by the accused who is alleged to have committed an offence under section 376 AB of IPC, In such case, it is option A, mandatory to give notice to such bail application before granting bail to the public prosecutor within a period of 15 days from the date of receipt of notice of such application. Option B, mandatory to give notice to such bail application before granting bail to the public prosecutor within a period of 7 days from the date of the receipt of notice of such application. Option C, not mandatory to give notice to the public prosecutor if the complainant or informant is presented through a private counsel. Option D, not mandatory to give notice to the public prosecutor if the court considers that it is not practicable to give such notice. In question number 1019, correct answer is option A, that is mandatory to give notice on such bail application before granting bail to the public prosecutor for within the period of 15 days from the date of the receipt of notice of such application. Question number 1020. As per the Criminal Law Amendment Act 2018, the presence of informant or any person authorized by him shall be obligatory at the time of hearing of the bail application in respect of the offences under which of the following sections of IPC. Here correct answer is option B, that is section 376 clause 3, section 376 AB, section 376 DA and section 376 DB. Question number 1021. Whether before the conclusion of the trial and before disposal of the appeal, accused can be asked to execute bail bonds to appear before the High Court. Here correct answer is option A, yes, as per section 437A of CrPC. Question number 1022. The general rule relation to fixing the amount of any bond under provisions as to bail bonds of CrPC is that it should not be penalty under the surety bond unreasonable, excessive, meager. Correct answer is option C, that is excessive. Question number 1023. Propositions as regards the liability of the surety under the surety bond are: first, the liability of the surety is mutually exclusive of the liability of the accused under his personal bond. Second, the liability of the surety is contingent on the liability of the accused under his personal bond. Third, the liability of the surety is limited to the amount of the surety bond. Now, for which of the following is correct? Here, in question number 1023, correct answer is option A, that is first and third option is correct. Question number 1024. Under which provision can the court issue a warrant of arrest against a person released on bail and require him to furnish insufficient sureties? Correct answer is option D, that is section 443 of CrPC. Question number 1025. Penalty under the surety bond can be remitted in full or in part. Option A is the right answer. 1026. Under CrPC, where a surety to a bond dies before the bond is forfeited. Here correct answer is option D, that is his legal representative shall become liable in respect of bond. Option D here is the right answer. Question number 1027. Cash in lieu of surety bond can be permitted wide. Correct answer is option C, that is section 445 of CrPC. Question number 1028. An order passed by the magistrate under section 446 of CrPC is appealable to option A, session judge. Session judge here is the right answer. Question number 1029. In case where penalty cannot be recovered from the surety under section 446 of CrPC, the court can order for imprisonment for surety. Option A, in civil jail for a term may extend to 6 months. Option A is the right answer. Question number 1030. In which of the following provisions criminal procedure is not related to appeal? Option A, section 86, section 449, section 450 and section 454. Correct answer here is option C, that is section 450 is not related to appeal. Question number 1031. Order of disposal of property at conclusion of trial is passed under. Correct answer here is option B, that is section 452 of CrPC. 1032. Order passed under section 451 CrPC is an interlocutory order. Correct answer is option A. Question number 1033. In which of the following sections section 127 of CrPC deals with the order for custody and disposal of property pending trial? Here correct answer is option A, that is section 451 CrPC. 1034. In reference to the order for disposal of property at the conclusion of the trial, criminal code under section 452, what is not correct? Options are by destruction, by confiscation, delivery to any person claiming to be entitled to possession, D, by declaration of title to any person ownership of the property. Here in this question it has been asked which of the following is not correct. Option D is not correct. Question number 1035. A criminal court at the conclusion of the trial may order option A, restoration of possession of immovable property to the person who had been dispossessed therefrom by the use of criminal force or by criminal intimidation by the person convicted. Option B, the destruction of pornographic material in respect of which the conviction was recorded. Option C, both A and B, and option D, neither A or B. Here correct answer is option C, that is both A and B. Question number 1036. Section 451 and section 452 of CrPC essentially deal with the disposal of property by the criminal code. The basic difference between the two is option B is the right answer, that is section 451 is attracted during inquiry of trial and section 452 is attracted after conclusion of the criminal trial. Question number 1037. By the Criminal Procedure Amendment Act 2005 in section 459 of CrPC, the word less than 10 rupees have been substituted by the words option A, that is less than 500 rupees. Question number 1038. Irregularities which do not vitiate trial have been stated in under section 460 of CrPC. Option A is the right answer. 1039. An irregularity by the magistrate in which one of the following cases will not vitiate proceeding? Here correct answer is option C, that is tendering pardon to accomplice. Question number 1040. Which of the following irregularities do not vitiate the proceeding if any magistrate not being empowered by law in this behalf does any of the following things? Option A, makes an order under section 133 of CrPC as to a local nuisance, makes an order under part C or D of the chapter 10 of CrPC, holds an inquest under chapter 176 of CrPC, makes an order for maintenance. Here correct answer is option C, holds an inquest under section 176 of CrPC. Question number 1041. When will proceedings be vitiated if the magistrate is not empowered to do so? To issue a search warrant under section 94 CrPC, to hold an inquest under section 176 of CrPC, to try an offender summarily, to tender a pardon under section 306 of CrPC. Here correct answer is option C, that is tries an offender summarily. Question number 1042. Which of the following irregularities is not covered under section 460 of CrPC? Option A, to tender a pardon under section 306 of CrPC, to issue a search warrant under section 94 of CrPC, hold an inquest report under section 176 of the CrPC, to attach and sell property under section 83 of CrPC. Here correct answer is option D, that is to attach and sell property under section 83 of the CrPC. Question number 1043. The proceedings before a criminal court are vitiated if the presiding magistrate, who is not empowered by law to do so, issues a search warrant erroneously but in good faith, holds an inquest report under section 176 of CrPC erroneously but in good faith, tries an offender summarily, all of these. Here correct answer is option C, that is tries an offender summarily. Question number 1044. Which of the following irregularities of a magistrate not empowered by law to do so vitiates the proceeding? Option A, to hold inquiry under section 176 of CrPC. Option B, to make over a case under subsection 2 of section 192 of CrPC. Option C, to make cognizance of an under clause C of subsection 1 of section 190 of CrPC, to tender pardon to accomplice under section 306 of the CrPC. Here correct answer is option C, to take cognizance of an offence under clause C of subsection 1 of section 190 of the CrPC. Question number 1045. Under CrPC, the irregularities which vitiate trial have been stated in option A, section 460, option B, section 461, option C, section 466 and option D, section 467. Correct answer here is option B, that is section 461. Question number 1046. Which of the following irregularities of a magistrate not empowered by law do so does not vitiate the proceeding? Here options are calling of record to exercise power of revision under section 397 CrPC, taking cognizance of an offence under clause A or clause B of the subsection 1 of section 190 of the CrPC, decision of an appeal, revision of an order passed under section 446 of the criminal procedure. Here correct answer is option B. Question number 1047. Section 464 of CrPC deals with the effect of option A, omission to frame charge, absence of charge, error and in charge, all of the above. Here correct answer is option D, that is all of the above. Question number 1048. If the offence is punishable with fine only, the period of limitation for taking cognizance of it shall be, correct answer is option B, that is 6 months. Question number 1049. The period of limitation means the period specified under section 468 of the CrPC for taking cognizance of an offence, investigation, filing charge sheet, none of the above. Here correct answer is option A, that is cognizance, taking cognizance of an offence. Question number 1050. In computing the period of limitation, which of the following shall be excluded? Option A, the time during which the offender has been absent from India or from any territory outside India which is under the administration of the central government. Option B, the time during which the offender has avoided arrest by absconding or concealing himself. Option C, both A and B, and option D, none of the above. Here correct answer is option C, that is both A and B.